Okay. Next case is JD Development versus ICS Contractors.
Good morning, Your Honor. David Fraser for the appellants. May it please the court, I'd like to reserve 5 minutes for rebuttal.
Sure.
This is an appeal following a jury verdict on the principal issue that was tried was an express written breach of contract. As background, the document that was attached to the complaint, it had some pretrial litigation on whether that constituted a contract and whether the invoices that were sought to be recovered at trial were part of this contract. The contract which we lost that issue.
What was advanced as a contract was really the bid, is that right?
That's correct, Your Honor.
And then both parties operated under the, I guess, the assumption that the bid was an enforceable agreement because the first few sections that were to be completed pursuant to the bid were in fact completed before the firing occurred. Is that correct?
That's correct, Your Honor. I guess we operated under the assumption we lost the argument that this constituted a contract. The court denied that argument at a motion to dismiss. And at that point in time, we argued that this
basically you're saying that even though the bid is a contract, these invoices that were the subject matter of the lawsuit don't come under the umbrella of the bid. Is that?
That's absolutely
in a nutshell,
correct.
That's your claim, right?
That's the claim, Your Honor, because if we look at the invoices, they're time and material invoices. There's about 525 hours of machine rental, about 30 hours of labor. If we look at the bid document, it's a unit price proposal. There's nothing stated on there for machine rental. There's nothing stated on there for labor. Interestingly, the work that was performed, 525 hours of dozer rental, excavator rental, those types of things would fall under the bid categories of site development. This was site development work. So we sign a bid, which is going to have a unit price proposal. If you look at the bid, it talks about price per linear foot of curbing, price per cubic yard of trucking, and that's what we agreed to. Notably, we paid almost 100% of the bid price, and they didn't complete categories 4, 5, 6, 7, 8.
I was going to ask you about that. I think that the total bid price was about 520 something.
Yes.
520,000. And your company paid out about 507,000. Is that right?
That's correct, Your Honor. And also, if you look at the bid category left out approximately $130,000 of work that wasn't performed. So if you can understand termination, we're way over budget and we're way behind schedule. And then they present another $120,000 of time and material invoices. Now,
so the amount that the jury awarded is over and above the 507 that was already paid out. Is that right?
That's correct. So
so if the jury verdict were to stand, then in your view of the case, you would have overpaid by 100,000 plus.
More than, I think it's a little over 200, and I think 250 is a number. That was my remitter argument, because we didn't get, the whole bid wasn't performed. There was less work than the bid was. Only categories 1, 2, and 3 of the bid were performed. But at its most fundamental sense, we argue that the appellee dug in on the express contract. It said no, and mind you, we're at the end of the statute of limitations. This was 4 years. So we know there's a statute of limitations difference between a written contract and an oral contract. And they dug in and said, this bid is an express contract for these items. Those items are nowhere mentioned in there. They make the argument that everyone knows that a contract, if it's clear, that's a legal determination for the court. It's well settled. However, if it's ambiguous, then we create a factual question for the jury.
Now, this court let the jury decide whether or not the invoices were covered by the bid.
Right, and which was a clear legal error, because no reasonable person or jury or court can read the bid and say that there's an amount in there for hourly work or there's an amount in there for machine rental. Those words don't exist. The rates don't exist. It's a unit price proposal. It's cubic yards, trucks of aggregate hauled out, trucks of fill brought in, sand, those types of things, feet of.
And if I may, Mr. Fraser, how do you respond to your opponent when the opponent said, well, even if you accept your position, the fact of the matter is maybe your clients have gone beyond that or waived that because there were emails going back and forth that basically says, as we agree to all of that's not contract work, we will bill it with bill that will be billed time and materials. And I think the language was using Blue Book rates, and then basically keeping that open, and that was acknowledged by your client. How do you respond to that?
First off, those emails, that's not part of this record. There's no such emails. Or that would be news to me to say that this work was approved on a time and material basis.
But this was the exhibit that was provided at trial. That's what I'm referring to. I think it's Plaintiff's Exhibit J.
Right. Okay. So I think the argument with it, or the question I have or point there, is that we agreed to a Blue Book rate on that. My response to that would be, that wasn't the theory that was advanced in the pleadings. And I don't cite the case in my brief, but there's plenty of citations that a party is limited to the claims that they raise in their pleadings. They raise an express written contract in their pleadings. So if now they're relying upon documents outside the express written contract, that's what we argued at the motion to dismiss stage, and we lost that because they came in their response. We have it in our appendix. The response was, you must take our allegation as true that the document attached to the complaint is the entire contract. And that's what it was. That's what we advanced on. Even at trial, the court prevented the appellee from arguing outside the express written contract. So the issue for the court is, does this bid, which they say was the express written contract, include that? That furthers my point. If they're now going to bring in documents outside this express written contract, that goes further to my point that there was something else outside this contract that constituted the party's agreement, which we weren't put on notice of. We couldn't have prepared a case for it. Wouldn't have been relevant. If a party is advancing an express written contract, I can't bring in other items, extraneous items, like your Honor pointed out, which have been a separate agreement to do other work on time and materials or use the Blue Book. That's a separate agreement that wasn't advanced at this trial. So we didn't have an opportunity to respond to that in discovery. Frankly, as a litigator, you can't bring those things in. It would be irrelevant to an express contract claim if I'm bringing out extraneous or parole agreements when the plaintiff chose to advance an express contract. So I guess
my point is, these were invoices, and I think I'm referencing the invoices that were at issue, the 1699, the 1720 to 1725, the 1699, and it was alleged, I guess that's during the trial, if you look at the transcript, that was partially paid. And so my understanding is, in looking at the record, that your client had agreed to the rates in these invoices, as well as these invoice activities for which, like the rental equipment and labor listed on the invoices were employed. I mean, that's how it was presented. Is that incorrect?
That would be incorrect. We never agreed to those rates. It was our position that those invoices came after termination. We never saw those. We didn't think we saw those for years later. And just so we're clear, the appellee's brief doesn't say that we agree to those invoices. I forget the page of it. I think it was, where did I have that page? It's during the testimony of the corporate representative of the appellee. He's asked, did they agree to the scope of this work? Yes, right, the scope of the work, but not the price of the work. It was our position that the scope of this work is already covered in the bid. Again, they're double dipping here. They charge us 550 hours for dozer rental, and I signed a bid, and the first section of the bid was $302,000 for earthwork and grading. That's covered in the bid. Our contract's a bid, and again, they advance an express written contract. What you're now suggesting is that we had a separate agreement, acquiescence, a written email, but that's not what was pled. That's something totally different.
I'm making reference to the trial itself, what the jury has heard, what was presented before the court. And this is what I'm referring to.
Right, and then
I'm not suggesting anything. I'm just saying what was in the record before us, sir.
I apologize, but we strenuously objected and the court agreed. The court said in our preparing for our closing arguments that the attorney, the appellee's counsel, would not be allowed to argue anything outside the express written contract. And I actually asked for the instruction to tell the jury, she used the standard. I said, look, we can't confuse the jury here. Tell them that they can only look at the express written contract. The court said, no, we won't let them argue that. But they very must have strayed outside the express written contract if they were awarded these invoices, because these invoices aren't mentioned anywhere in that contract. So, you know, I don't think that, as far as count one, which was a written contract, which they provide, and even we can just break through the counts that went to the jury in the verdict form. I don't think a reasonable person can look at this express contract count and say that the bid covered it. Maybe there was a different agreement that took place, but that wasn't what was tried. And our Supreme Court has said that, you know, the pleadings set the trial. We just talked about due process in the other argument, but our Supreme Court in Pro Art Dental versus Strategic Group LLC 986 Southern 2nd 1244. It says the court lacks jurisdiction to hear and determine matters which are not part of the proper pleading. At no time was a motion to amend the pleadings to conform to the evidence made. We would have strenuously objected. And, you know, so it advanced only on an express written contract. It just wasn't tried. And the jury kind of, if they found that, it was outside the instructions. So we believe the court.
Let me ask you a question, and I don't know whether this is correct or not, but in the counter plaintiff's motion for judgment on directed verdict, the JNOV motion, the argument was made that because items 5, 6, 7, and 8 were not performed, that you have to reduce the value of the bid to $391,000 and change. In other words, that's what would have been owed because several of the sections weren't performed. Are you with me so far?
Yes, Your Honor.
However, your company actually has paid out $507,000 for, and I don't know if this is correct or not. This is my interpretation of this, and I want you to shine some light on it if you can. If the work, once you reduce the amounts that weren't performed, if you take that out of the 520, you end up with 391, 839, 45. But yet there were payments made of 507, 892. And as I heard Judge Kazam, I was wondering whether perhaps some of that was the items that were agreed to as overages, as opposed to the items that are on the invoice. And I don't know if that's accurate or not, but I would like you to hear what you have to say about it.
The numbers are accurate, Your Honor. And certainly if my client paid those invoices, it would be hard for him to say that he didn't agree to those overages. But those overages, those invoices were all submitted pursuant to the bid, right? We have, and mind you, I believe the truck tickets came into evidence. Trucks in and trucks out were being tracked. So we know the cubic yards in those trucks, because that's what the bid breaks it down for, is cubic yards of trucking, linear feet of swaling, those types of things. So yeah, there were some overages that we did agree to and we paid, but that was based upon the bid documents. Following all of that, we get hit with the disputed invoices, which we never saw during the time, and certainly would constitute overlapping work. If they're now, I agreed to trucks in and trucks out. Well, how do those trucks get loaded? With excavators, how the aggregate cleared with dozers. Now they're handing me a rental bill for the things that they just did to perform their unit price bid.
So you're saying that the $116,000 extra that was paid was pursuant to the bid documents?
That would have been pursuant to the bid documents.
And you're drawing the line saying with the invoices are not pursuant to the bid documents. So we've already paid 507. We shouldn't have to pay another 105.
Right. We've already exceeded the bid. And, you know, again, this was the case.
I guess or whether you're required to pay it or not really isn't the point. The point is that that's not what was sued on. That's your argument.
It's not what was sued on. That's not what was agreed to. If a party's agreed to a unit price bid, I don't know how they get hit with time and materials when this is what was sued on as the express contract. And while we're talking about those bid documents.
Now that you and Judge Black are now into your rebuttal time.
Okay. I'll move very quickly. I know we were talking about mortgage documents.
These numbers got me excited as a former accountant. I apologize.
I know that the court's done hearsay a lot. We were just talking about the mortgage documents, so I know we know hearsay. Look at the invoices. They're block billing. The person, when we voir dire the witness at trial, he admitted he didn't perform the work. So he's authenticating block invoices. They cover 2-week periods. Those are not the types of business records that we rely upon. Those are just block invoices. The business records should have been the foreman records, the diesel receipts, those types of things. This doesn't qualify as a business record. I'll rely upon my papers for that. Now, real quickly before I go, I'll try to say 2 minutes for rebuttal. If we just look at the jury verdict form, I rely upon my papers that say a verdict form that is inconsistent on its face and it is invalid, and so would there be a judgment based upon it. The jury verdict here, it awarded breach of contract. It said, don't go any further. It then awarded it then awarded an equitable remedy. You can't have all three of those. That jury verdict is a legal impossibility. Once you have a contract, you can't have an equitable contract. Once you have a contract, you can't have an open account. I cite the open account case law and the implied contract case law that says exactly that. Showing further confusion of this jury, in count 1, they actually awarded attorney's fees and costs. There was some other guidance in that jury verdict. I've done several, I probably not as many as you all have, business jury trials. Something else was controlling that guidance. Attorney's fees, maybe. Everybody knows they have to pay attorney's fees, but the verdict form expressly says costs. How would somebody in the jury verdict, that's nowhere, not even close to being an instruction to the jury. They were being pushed by somebody else in that jury jury room. Someone made up their mind that they were going to pay this plaintiff, checked all the boxes, and even awarded attorney's fees and costs. That verdict form cannot stand. The judgment, therefore, is also invalid, and I'll reserve the rest of my time for rebuttal.
Morning, Your Honors. May it please the court. My name is Kritika Venugopal, and I represent the appellee, ICS. So I want to start out by addressing the jury verdict. For one thing, Florida case law requires that appellant make that objection before the jury was discharged, and they never made that objection before the jury was discharged. And so they can't now raise that objection based on inconsistency. And even if they had raised it, the jury verdict was ultimately resolved in a way that Florida case law requires it to be resolved, which is to have the jury go back, be re-instructed, and then clarify what the verdict says essentially. So ultimately, the finalized verdict form does not have any inconsistency. It only finds liability on the breach of contract count in the amount that was requested. Now, to address a couple other points that appellant raised, for one thing, ICS always maintained that the activities recorded in the unpaid invoices were based on a written contract theory. Any agreements that were introduced into evidence was to show that the parties had agreed on the activities that were contemplated within the written bid.
What would you point me to in the record that would indicate that the bid amounts were contemplated? I'm sorry, that the invoices that were sued on are contemplated by the bid.
Well, I would.
What connects the 6 or 7 invoices to the bid?
Well, I would point to the express phrases within the bid itself. We said I think we had ICS's representative testify that there was always a chance of things to change, and they knew that this was.
Are you referring to Jason Clark?
Yes, I am referring to Jason Clark.
Because I was going to get to that. On pages 186 through 189 of the record, Mr. Clark has asked repeatedly about the invoices.
Would you like me to answer your question that you just posed, or?
Go ahead.
Okay. So there were express phrases that were included in the bid to reserve against the possibility of changes occurring, because this contract was for site development work, and there was non-party testimony in addition to Mr. Clark's testimony that things were subject to change. This was, unpredictable. It was site development. Things could just be found. And as a result, the bid had phrases such as, price does not include reserving against that possibility again for changes. So price does not include unforeseen items, or removal or replacement of unsuitable materials, and that the bid was expressly based on plans dated 2015 or 2014. And there was testimony.
The bid doesn't say anything about equipment rental or man hours, right?
Right. So
isn't it kind of a stretch to say that these invoices fall within the umbrella of the bid when they aren't mentioned? And in fact, wasn't that the gist of Mr. Clark's testimony? He was asked a series of questions about what whether these bids come under the umbrella of the bid, and he repeatedly says no.
I don't believe so, Your Honor. I would have to
Well,
double check.
look at page 188 of the record. The question is 1721.
Yeah.
Your excavator, case dozer, loader, site, dumper, roller, motor grader, none of that corresponds to what's in the bid, correct? And he says, correct. Next question, in 17, let's turn to the next one, invoice number 1722, same thing. Excavator, date, case dozer, loader, site dumper, motor grader, that's not listed in your bid, correct? Answer, correct. Question, 1723, same thing. Excavator, case dozer, loader, that's not included in the bid, correct? Answer, correct. It said same thing, 1724, 1725. He gets taken through the whole list of invoices and he says none of them to be found in the bid.
And I agree with that.
How do I reconcile
that? Those things aren't expressly found within the bid because they were things that came up as things changed. And so the best way to measure those items that weren't expressly found in the bid, for
instance,
why
didn't he, in that case, why did he say, well, if you look at the bid on page 72A, you'll see where we made allowance for that.
Well, Your Honor,
he doesn't say that. He just keeps saying, saying correct. None of it's in the bid.
Because he was trying to answer the question honestly, as Mr. Frazier was asking him, were those things expressly mentioned on the bid?
But that's the whole gist of this lawsuit, is whether or not they're included in the bid or not.
I'm sorry, could you say that one more time?
The whole crux of this case is whether or not these invoices are included within the bid, and he just keeps saying no, they're not.
The crux of the case is whether the activities for which those rentals and the labor was used was included under the contract or not, which means additional works, changes,
right? I agree.
Works.
And he continues to say correct, they are not included.
Well, the question is, does case dozer or excavator, case dozer, loader appear on the face of the bid? They don't, and he could only say that they don't. That doesn't take away from the fact that those activities for which those items were used were covered under the bid. And he testifies as much in another part of the trial transcript during his direct examination, I believe, where he positively states that the activities billed for in the unpaid invoices were covered under the express terms of the contract.
I don't recall reading that, but if you point me to something, I'll be glad to consider it.
Absolutely, Your Honor. I think it's in our brief. I believe in the first portion, there's at least two places in his direct examination where he says, yes, these items were agreed to. He's testifying on the emails. And those were I believe, November to December invoices and the invoices beforehand even. I think he says that JD Development was out there until the date of termination approving all the work, and that nothing was ever, rejected or objected to. So, and as I was saying, I think I want to move on to the $507,000 payment. The way to negate any kind of suggestion that it's an overpayment is by looking to the paid invoices that were introduced by ICS on their part. And even the paid invoices, just as a side note, referring back to the discussion we were just having, the paid invoices actually have activities that weren't expressly listed on the bid. And now I'm sorry, I'm jumping a little bit back and forth, but back to the $507,000 overpayment. So that cuts to the heart of the disagreement. There was no overpayment when you consider the paid invoices, including items that weren't expressly mentioned in the bid or prices that weren't expressly mentioned in the bid. So to the extent that the $507,000 follows the paid invoices, it's accounting for numerous items that are not within the $387,000 categorical summary of the prices that are stated on the bid, if that makes sense. And it's honestly, it's accounted for in that regard. Now to one additional argument that appellant raised earlier. So there was a legal determination on the record that the bid constituted a contract. I think it was trial transcript page number 309, where Judge Brody specifically makes that legal finding. But I think there were still factual issues, as we've argued throughout this entire proceeding, as to whether the bid covered unforeseen items or things that weren't expressly mentioned in the contract. And that was a dispute of fact, which is appropriately determined by the jury. And not only that, there was actually another contract formation issue going to whether appellant had even accepted the bid through their agent. I think it was Mr. Ademchik, which was, as we've cited to in our brief, is an issue for the jury. So there were at least two issues that should have been decided by the jury. And so that ruling was properly made.
Just so I'm totally clear about this, because I think it's important. What section exactly of the bid would you tell me encompasses the invoiced items?
I would point to the notes. So at the very end, it says that this is a unit price proposal. There's a couple of phrases actually that
be very specific, because this is what I think is important, and I'm all ears. I want to know where in the bid are the invoice items covered?
Absolutely, Your Honor. So again, I would point to the notes section of the bid, the express terms of the notes section, which specifically states that the price does not include unforeseen items or I believe replacement or removal of unsuitable materials, buried items. There was another one, I believe. This is a bid based on plans made by Holy Montes dated 2014-15, and that reserves and contemplates changes and the payment for those changes and the performance of those changes and things not expressly mentioned in the bid. And at the very end, if I may go to just one more section.
Yeah, go to as many as help you.
So at the very end, where JD Development appellant's agent signs the bid, it says that this whole thing is accepted under the terms and conditions set forth above. And the notes were obviously a condition of the bid, and they were agreed to. So it's based on that we're actually bringing this whole suit, based on the express terms of the contract, which was what we've always maintained throughout the entire suit. And if there are no other questions in that regard, that kind of leads to my next point, which is regarding the jury instructions. The jury was properly instructed because, as I just said, ICS's theory has always been based upon an express written contract. So there was no need to reiterate that, and it would have been a redundancy for the jury. In fact, even in closing arguments and in the direct testimony of Mr. Clark, ICS's representative, counsel for ICS specifically referred to the bid as a written contract or a bid contract. There was even non-party testimony where counsel for ICS helped elicit the response that the bid was the standard contract for this type of work, which is site development work. And it was just that the agent saw it as a contract. And so
I don't think it's being seriously contested that the bid wasn't a contract. The question is whether the invoices fall within the bid. Okay, Your Honor. All right. Let me just see if there are any other issues relating to that I would be able to assist with clarifying. I believe there was an issue raised on the evidentiary rulings made by Judge Brody in the lower court. On that issue, first, it was, I believe, the statement balance and the invoices themselves. As for the statement balance, I think all of the responses required to lay a foundation were elicited from the testimony. And
the person testifying to the invoices and the statement balance did not necessarily need to know how each were made. They only needed to know, they needed to have enough familiarity with the process. And we've cited case law going to that. And the court, again, exercised its discretion in admitting these items and determining whether the proper foundation had been laid. And I believe with the statement balance, the at or near requirement was met. And that was a big issue brought up in appellant's brief. And the requirement, just to explain, only mandates that the document be created at or near the time of the activities recorded in the document. Well, the activity recorded in the statement balance was a listing of the invoices, or a summarization in a sense. And there was testimony that the making of that statement balance was by just simply clicking a button on QuickBooks or the online accounting books of ICS, that was done on 8/31/16. Moreover, there's a case that appellant cites in their brief, Coates v. State, which itself actually states that a printout, which in this case the statement balance was, of information, a printout of information is admissible under the business records exception, especially when it's just an automated clicking of the button that, you know, produces or compiles the information from a digital system. Going to the invoices, the judge in her discretion determined that the at or near requirement was met for the invoices as well, since that was another issue brought up in appellant's brief. Ultimately, the judge decided that there was enough there, enough presented for the reliability and the trustworthiness of these documents to allow them into evidence. And the issue on block billing, I think that was what was raised with regard to the at or near requirement, whether it could have been met, and the judge in her discretion decided and adduced that it could in this case. I believe those were really the only issues that were raised by appellant here. Anything else, I rely on the arguments contained in our brief. If there are any questions, I welcome them now.
Thank you, counsel.
Thank you, Your Honor.
Venugopal. Mr. Fraser, you have, my view is down to 2 minutes.
Okay. Your Honor, to Judge Black's point, if we look at what counsel cited as bringing the extra work into the bid, those extra provisions say bid does not include fence, price does not include buried items, bid based upon Whole Montes plans. At the time of the contract, not every activity performed can be explicitly included. Unit price proposal, field quantities will be field measured. Final quantities will be field measured. A contract is a meeting of the minds upon where we agree to these rates. That's simply saying there's things we don't know about. We'll agree later on, possibly at a different date. This bid doesn't include those things. I pulled up Exhibit J, which Judge Kuzem, you pointed out. In Exhibit J, that's an email from their client, not ours. We never affirmed that. But look what he says. He says in the second portion, it says, this is not contract work. It's billed separately using Blue Book rates. We never affirmed that or agreed to it, but that's his own word saying this isn't a contract. They sued on the express written contract. That's what was tried. There's a stack of cases saying you can't prevail on something outside the pleadings. There was never a motion for leave to amend. With respect to not raising the jury verdict instruction, look at the transcript portion of this. The judge only published count one. She didn't keep reading, and she actually handed a pen back. So that's one problem. I have the obligation to let the trial judge know when an error has been made, so she has the opportunity to correct it. But I can't make her known of an error that I never know of. The clerk only published count one. They didn't read that they also awarded open account and also awarded implied contract. As soon as were made aware of that, we filed a post-trial motion to correct that, which is what we have to do. And then, the court actually had them strike out the attorney's fees. I thought maybe they were signing it. We never got that verdict form in court. And following a jury trial is not the best time to tell the trial court judge, hey, judge, just want to look over your shoulder and make sure you read that document correctly. As soon as were made aware of that mistake, we pointed it out. But this verdict form has problems. There's no ambiguity here, a factual ambiguity. I cited in my reply brief, I use kind of an exaggeration to illustrate my point. A contract for the purchase of a boat is an ambiguous way of now purchasing a house, right? We say, well, look, you bought this thing. Now the jury is going to conclude what other things were ambiguously left out of the clear written documents. Finally, I rely upon my papers for this. In closing arguments, we made the point, we pointed out that this work that they're charging us for, we had a lien waiver, a lien release, right? This work, we had a lien waiver that covered this work. They said, well, the lien waiver doesn't mean that you paid it for us. We just means you can't lien the work. We had a building expert. I'll conclude. We had a building expert who was going to say that that's industry standard. When you release a lien, you're walking away from payment. Our expert was stricken without meeting the requirements of Binger.
At that point, where you're supposed to say, so we request that you reverse the judgment. So your time's up.
Sorry. We request that you reverse the judgment, and I rely upon my papers for this. Thank you. I apologize.
Oh, that's okay. I was in your situation for many years, and I argued all the way back to my seat. So thank you both very much.
Thank you.
In order to leave our little courtroom here, you click the leave button that is on your Zoom screen. It should be in red, and then you will disappear. We'll continue to think about you, though.
Thank you, Your Honors. Have a great day.
You too.
Thank you very much.
Our next case is JP Morgan Chase Bank